Ipra Law, or the Indigenous People Rights Act Law. Constitutional anchors of Ipra Law. The state recognizes and promotes the rights of indigenous culture communities within the framework of national unity and development. The state, subject to the provisions of this Constitution and national development policies and programs, shall protect the rights of indigenous cultural communities to their ancestral lands, to ensure their economic, social, and cultural well-being. The Congress may provide for the applicability of customary laws governing property rights or relations in determining the ownership and extent of ancestral domain. The state shall recognize, respect, and protect the rights of indigenous culture communities to preserve and develop their cultures, traditions, and institutions. It shall consider these rights in the formulation of national plans and policies. Republic Act 8371 was signed into law on October 29, 1997. Landmark legislation is to correct historical injustice, enforce constitutional mandates, observe international norms, whereby the salient points are the following: native titles, the four bundle of rights, creation of the NCIP, delineation and recognition of ADs and ALs, free and prior informed consent, primacy of customary laws, and quasi-judicial powers. Indigenous culture communities or indigenous peoples. The indigenous cultural communities or indigenous peoples are the homogeneous societies whereby continually lived as organized community bounded and defined territory. They occupied, possessed, and utilized such territories since time immemorial under claims of ownership, sharing common bands of language, customs, traditions, and other distinct cultural traits, or who have become historically differentiated from the majority of the Filipinos. There are at least 110 ethno-linguistic groups comprising the ICCs or IPs with a population of about 14 million based on extrapolation of Philippine population growth. In here, ethnographic map shows the location of ICCs or IPs. The four bundles of rights defined under Ipra law. The four bundles of rights are the following: right to ancestral domains and lands, rights to self-governance and empowerment, rights to social justice and human rights, and the right to cultural integrity. The right of ancestral domains or lands, whereby the ownership, develop and manage lands and natural resources, stay in territories, rights in case of displacement, regulate entry of migrants, claim reservations, right to safe and clean air and water, resolve conflict through customary law, and to transfer ancestral lands, to redeem ancestral lands lost through vitiated consent. Note that ancestral domains or land are beyond the scope of Regalian doctrine. Under such rights covers also the native title, refers to pre-conquest rights to lands and domains which as far back as memory reaches have been held under a claim of private ownership of ICCs or IPs, have never been public lands, and are thus indisputably presumed to have been held that way since before the Spanish conquest. Ancestral domains, however, are areas generally belonging to ICCs or IPs, comprising lands, inlands, water, coastal areas, and natural resources therein, held under a claim of ownership, occupied or possessed by ICCs or IPs. by themselves or through their ancestors, communally or individually since time immemorial, continuously to the present except when interrupted by war, force majeure, or displacement by force, deceit, stealth, or as consequence of government projects or any other voluntary dealings entered into by government and private individuals or corporation, and which are necessary to ensure their economic and social cultural welfare. Ancestral lands are lands occupied, possessed, and utilized by individuals, families, and clans who are members of the ICCs or IPs since time immemorial, by themselves or through their predecessors in interest, under claims of individual or traditional group ownership, continuously to the present. ADs or ALs covers not only the physical environment, but the total environment, including the spiritual and cultural bonds of the areas. ADs, however, are private but community property, cannot be sold, disposed, or destroyed. Right to self-governance and empowerment. This is to freely pursue economic, social, and cultural well-being, free prior informed consent in use of resources therein, use commonly accepted justice system or conflict resolution institutions or peace-building processes or customary laws, participate in decision-making that may affect them, mandatory representation in policy-making bodies and local legislative councils, determine their own priorities, organize, granted means to fully develop their institutions and initiative. Social justice and human rights. This will give equal protection and non-discrimination, rights during armed conflict, equal opportunities and treatment, basic services, protection to women, children, and youth, an integrated system of education. Right to cultural integrity, protection of culture, traditions, and institutions. These must be considered in the formulation and application of national plans and policies. Access to cultural opportunities, recognition of cultural diversity, practice and revitalize their customs and traditions, and the state must protect manifestations thereof. Religious, cultural sites and ceremonies, funds for archaeological and historical sites, and ownership and recognition of cultural and intellectual rights. The indigenous peoples' ancestral domains and spirituality constitute the principle that land is life. Ancestral domains are so replete with wonders of nature and rich biodiversity, teeming forest and lush of green environment, beauteous natural landscapes, diverse flora and fauna, sustained source of livelihood, market and pharmacy, and a cultural heritage. In this slide, the Philippine map showing approved CADTs as of December 2017. In here, a map showing the approved CADTs. Ancestral Domain Sustainable Development Protection Plan is that the plan of ICC or IPs in a given ancestral domain for the sustainable management and development of their land and natural resources and human and cultural resources. This development plan is a long-term spatial and comprehensive development plan. Also, the plan is a tool for empowerment of the IP community. It also documents the policies and mechanisms for recognizing and promoting the rights of ICCs or IPs and their rights to ancestral domains. The key features of the Ancestral Domain Sustainable Development Protection Plan. 1. Indigenous knowledge system and practices based. 2. IP rights based. 3. Ancestral domain-based. 4. Community-based. 5. Initiated by the concerned IC or IP community. 6. Emphasis on socio-cultural preservation. 7. Gender sensitivity. And written in the vernacular. NCIP Administrative Order Number 3, Series of 2012, the revised guidelines on free and prior informed consent and related processes of 2012. Instructions for use for AO Number 3, Series of 2012. Section 59 states that all departments and other governmental agencies shall henceforth be strictly enjoined from issuing, renewing, or granting any concession, license, or lease, or entering into any production sharing agreement without prior certification from the NCIP that the area affected does not overlap any ancestral domain. Such certification shall only be issued after a field-based investigation is conducted by the Ancestral Domain Office of the area concerned, provided that no certification shall be issued by the NCIP without the free and prior informed and written consent of ICCs or IPs concerned. Provided further that no department, government agency, or government-owned or controlled corporation may issue new concession, license, lease, or production sharing agreement while there is a pending application for a CAD-D. Provided finally that the ICC's IPs shall have the right to stop or suspend, in accordance with this Act, any project that has not satisfied the requirement of this consultation process. Certification Precondition Issued, or the FPIC. Here is a flowchart on how to acquire the certification. Here is the validation process. First, your request for validation. Second, there will be field validation. And lastly, the preparation of CP. Here are the salient provisions. No similar application in one ancestral domain. Reports are under oath. Dormant CP on inactive application. Posting of bond. Royalties or CRDP. Reconsideration. Non-transferability. And visitorial and monitoring powers. The applicant is prohibited employment of threat, coercion, or intimidation or bribery. NCIP officers' employment, however, is also prohibited in acceptance of receipt of money, gifts, or any valuable things from the applicant, and use of falsified narration of facts. The IP community or member and or elder or leader is prohibited in the solicitation and acceptance of receipt of gifts, money, or other valuable things from the applicant, consorting or mediating with the applicant to unduly influence the result of the FPIC process. Moreover, NGOs, CSO, GAs, LGUs, and other groups are prohibited to influence or interfere with the FPIC process or to the community. The National Commission Indigenous Peoples. The NCIP shall protect and promote the interests and well-being of indigenous peoples with due regard to their beliefs, customs, traditions, and institutions within the framework of national unity and development. Here are the major functions of the National Commission in Indigenous Peoples. This slide shows the organizational structure of NCIP. NCIP programs provides policy, ancestral domain and land titling, Indigenous Peoples' Rights Protection Services, Human, Economic, and Environment Development and Protection Services. Comparative analysis on international laws, national laws, and Talaandig's customary laws on ancestral domains. The objectives of these works are the following: to understand customary laws of the tribe which are relevant to ancestral domain and land rights, to analyze or lay comparative analysis on the international, national, and customary laws, particularly those relating to establishing and recognizing ancestral domain with the aid of case law, to understand the efforts and initiatives of these indigenous leaders and individuals in establishing and recognizing land rights. The relevant laws anchored in this study: international laws wherein International Labour Organization Indigenous and Tribal Peoples Convention Number 169 and the United Nations Declaration on the Rights of Indigenous Peoples. On the other hand, on the national law, we have Indigenous Peoples' Rights Act of the Philippines of 1997. The International Labour Organization Convention Number 169 is an international treaty adopted by the ILO in 1989. The convention represents a consensus reached by ILO constituents on the rights of the IPs within the nation-states where they live and the responsibilities and obligations of the governments to protect these rights. It is based on respect for the cultures and ways of life of IPs and recognizes their right to land and natural resources and to define their own priorities for development. ILO Convention Number 169 by 1986 is concerned with the integrationist approach of Convention Number 107, prompted the ILO to begin work on revising the convention. In 1988 and 1989, the ILO drafted a new convention, the Indigenous and Tribal Peoples Convention. The revision to the Convention 107 forbade governments from pursuing approaches deemed integrationist and assimilationist. It asserts the rights of indigenous and tribal peoples to choose to integrate or to maintain their cultural and political independence. Article 8 to 10 recognize the cultures, traditions, and special circumstances of indigenous tribal peoples. The United Nations Declaration on the Rights of Indigenous Peoples is a legally non-binding resolution passed by the United Nations in 2007. It delineates and defines the individual and collective rights of indigenous peoples, including their ownership rights to cultural and ceremonial expression, identity, language, employment, health, education, and other issues. Their ownership also extends to the protection of their intellectual and cultural property. When the UN General Assembly adopted the UNDRIP in 2007, it did so after over 2 decades of negotiation between and among indigenous peoples and states, dating back to 1982 when the Working Group on the Rights of Indigenous Populations was established to prepare and draft of a declaration. After a decade of annual meetings, the Working Group produced a draft for internal consideration in 1993. In 1994, the United Nations declared 1995 to 2004 the International Decade of the World's Indigenous People and made one of the decade's explicit aims to completion and adoption of the UN Declaration on the Rights of Indigenous Peoples as the further development of international standards as well as national legislation for the protection and the promotion of indigenous people. In response to the Working Group's failure to reach an agreement on the declaration during these years, the UN declared a second International Decade of the World's Indigenous People Ensuing 2.5 years brought a roller coaster of hopes and disappointments for those advocating for the declaration. In 2006, moreover, in an effort to facilitate the adoption of the declaration at the first session of the newly formed Human Rights Council, the chair of the working group suggested a list of changes to the 1993 draft. A new draft including those changes was presented to the Council, which adopted the declaration during the first session in June 2006. The Council agreed to send the declaration to the General Assembly in what was considered a moment of success both for the Council and for the most indigenous peoples. The Indigenous Peoples' Rights Act was enacted on October 29, 1997 as one of the social reform agenda of the Philippine government. It aimed to correct the historical injustice which placed the IPs at a disadvantage in comparison to the rest of the society. It does not only contain a comprehensive list of rights of the IPs, but also establishes the lead agency for its implementation and the mechanism for the enforcement of these rights. Ipra recognizes the rights of the IPs to their ancestral land and domains and provides the identification, delineation, and certification processes of these ancestral land and domains. It also touches on the more general topic of human rights and social justice, and particularly provides for the rights of the IPs to self-governance and empowerment. Brief history of the Indigenous Peoples' Rights Act. Ipra, formerly known as Ancestral Domain Bill, was first filed in the Congress sometimes in 1987 under Senate Bill Number 909, authored by Senator Santanina Rasul, Senator Joseph Estrada, and Senator Alberto Romulo during the 8th Congress, but was never enacted into law. In the 9th Congress, Senator Rasul introduced Senate Bill Number 1029 and Senator Gloria Macapagal Arroyo introduced Senate Bill Number 1849. However, the bill was never sponsored and deliberated upon on the floor. Despite these failed efforts, the IPOs decided to give it another try. Decisions have been made during social negotiations among NGOs and POs to rename the bill from Ancestral Domain Bill to Indigenous Peoples' Rights Act to emphasize the holistic approach and character of the bill. A consensus was made in December 1995 between IP representatives and NGO representatives. In 1996, during the 10th Congress, Senator Juan Flavier sponsored Senate Bill Number 1728. In his sponsorship speech, he discussed the legal basis for the bill found in the 1997 Constitution. He also discussed the basic rights of indigenous culture communities, the contents of the bill itself, and the immediate need of protection of the Filipino indigenous people. Despite difficult hurdles and amendments enacted in the Congress that nearly brought the movement to its death, the House of Representatives finally approved the bill late in September 1997. President Fidel V. Ramos signed it on October 22, 1997, officially making it Republic Act No. 8371, Indigenous Peoples' Rights Act of 1997, which aims to recognize, protect, and promote the rights of indigenous cultural communities or indigenous peoples, and for the other purposes. The customary laws of Talaandig. The land is a gift from Supreme Being. Native title as the operative concept. The members of the tribes have the right to pass lands on from one generation to another. In case of land dispute, both parties will be brought to hold of peace to be heard in sala or trial, and communal property is observed among tribal members. The land is a gift from Supreme Being. The very fact and gist, as Dato Sawai holds, of existence of their lands is a blessing sent from above. The nature and extent of these lands and their territories are defined by the Almighty who nourishes them with bounties and resources. Hence, these natural resources have to be protected and upheld with utmost care and gratitude. Talaandig's god are the following: Luwitha Namintidan, the winged god; Diwata Makabugnaw, the pure white god; Agtayaban Migbaya, lord of the guardians; Mulug Nanguyaw-uyaw, the great planner; Takinanhu Magbaya or Gunduhu Namintidan, the lord of the decision maker; Magbabaya, one-headed god and decision maker and god of creation; Nangulimbit ha Sugoy, 10-headed god; Lalawin ha Diwata, the forbidden god; and Takinanhu Lumindib or Gunduhu Talabusaw, the lord of the warriors. In Ilo Convention Number 169, governments shall respect the special importance for the cultures and spiritual values of the peoples concerned with their relationship with the lands of their territories, or both as applicable, which they occupy or otherwise use, and in particular, the collective aspects of this relationship. United Nations Declaration on the Rights of Indigenous Peoples, whereby Indigenous peoples have the right to maintain and strengthen their distinctive spiritual relationship with their traditionally owned or otherwise occupied and used lands, territories, waters, and coastal seas and other resources, and to uphold their responsibilities to future generations. Indigenous Peoples' Rights Act, whereby ancestral lands or domains shall include such concepts of territories which cover not only the physical environment but the total environment, including the spiritual and cultural bonds to the areas which the ICCs or IPs possess, occupy, and use, and to which they have claims of ownership. The instruments aforequoted recognize the rights of ICCs or IPs to maintain, develop, and strengthen their distinctive spiritual and material relationship with the lands, territories, waters, and coastal seas and other resources which they have traditionally owned, occupied, or used. The first customary law of Talaandig works similar to the provisions of those laws which must be respected in so far as their lands are concerned. Native title as the operative concept. Their lands impart them a cultural identity, cultural integrity, spiritual and social wellness. Moreover, their lands impact directly on the recognition of their human rights, interrelated or interdependent. The concept recognizes traditional occupation of indigenous and tribal lands as adequate basis for the state to recognize and grant titles over these lands. This native title recognizes right of ownership over these kinds of lands regardless whether traditionally occupied or used by the individual members of the tribe of the community. Moreover, the concept defines lands that shall encompasses the aggregate areas of environment which either the entire community or individual members occupy and use. The indigenous peoples have occupied these territories and lands even before any central government was made in reality or established. These lands are held with aboriginal title, which is based upon traditional or immemorial occupation and use. The right of ownership. ILO Convention Number 169 states that ownership and possession of the peoples concerned over the lands which they traditionally occupy shall be recognized. In addition to this, measures shall be taken in appropriate cases to safeguard the rights of the peoples concerned to use lands not exclusively occupied by them, but to which they have traditionally had access for their subsistence and traditional activities. Particularly attention shall be paid to the situation of nomadic peoples and shifting cultivators in this respect. United Nations Declaration on the Rights of Indigenous Peoples states that indigenous peoples have the right to own, use, develop, and control the lands, territories, and resources they possess by reason of traditional ownership or other traditional occupation or use, as well as those which they have otherwise acquired. Indigenous Peoples' Rights Act states that indigenous concept of ownership sustains the view that ancestral domains and all resources found therein shall serve as the material basis of their cultural integrity. The indigenous concept of ownership generally holds that ancestral domains are the ICCs or IPs, private but community property which belongs to all generations and therefore cannot be sold, disposed, or destroyed. It likewise covers sustainable traditional resource of rights. The three laws clearly recognize the right of ownership of these indigenous peoples over their lands. This concept of ownership holds that indigenous lands are private but community property which belongs to all generations. Hence, the concept of ownership divests other individuals, apart from tribal members, to sell, dispose, or destroy these lands. The right to occupy. Ilo Convention Number 169, in applying the provisions of this part of the Convention, governments shall respect the special importance for the cultures and spiritual values of the peoples concerned of their relationship with the lands or territories, or both as applicable, which they occupy, otherwise use, in the particular, the collective aspects of this relationship. Moreover, in UNDRIP, indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. In Indigenous Peoples' Rights Act, ancestral lands or domains shall include such concepts of territories which cover not only the physical environment but the total environment, including the spiritual and cultural bonds of the areas which the ICCs or IPs possess, occupy, and use, and to which they have claims of ownership. Comparative analysis between these three laws appreciate or recognize the traditional occupation of indigenous and tribal lands, notwithstanding the individual or collective entitlement among them. The concept to occupy is recognized with their rights to develop, use, and control these lands. Moreover, the right also strengthens the spiritual and material relationship with their lands and entails upholding of communal responsibilities to future generations. The right to be protected by the state. ILO Convention Number 169 states that governments shall take steps as necessary to identify lands which the peoples concerned traditionally occupy, and to guarantee effective protection of their rights of ownership and possession. Adequate procedure shall be established within the national legal system to resolve the claims by the peoples concerned. UNDRIP moreover states that the states shall establish and implement, in conjunction with indigenous peoples concerned, a fair, independent, impartial, open, or transparent process giving due recognition to indigenous peoples' laws, traditions, customs, and land tenure system. to recognize and adjudicate the rights of indigenous peoples pertaining to their lands, territories, and resources, including those which were traditionally owned or otherwise occupied or used. Indigenous peoples shall have the right to participate in this process. Indigenous Peoples' Rights Act. The state shall protect the rights of ICCs or ICPs to their ancestral domains to ensure their economic, social, and cultural well-being, and shall recognize an applicability of customary laws governing property rights or relations in determining the ownership and extent of ancestral domain. Comparative analysis between the three laws. These laws have a similar mandate to collaborate with the government or state with regard to implementing and establishing process that would give due recognition to indigenous peoples' customary laws and land tenure system, whereby the government has the duty to protect the land rights of IPs to ensure economic, social, and cultural well-being. The government, moreover, has the obligation to adjudicate rights of IPs pertaining to their lands, territories, and resources, and other resources. The members of the tribes have the right to pass lands from one generation to another. The customary law underscores disparity from the normal or ordinary procedure of procuring individual title under Torrent system. As such, customary law embraces not the idea of titling a land, since every member of a tribe can establish ownership by occupancy through a long period of time, as previously discussed. The method of bringing these lands to forthcoming generations is made possible through hereditary succession. Transfer of valuable paraphernalia can be made which involves recognition of status and social positions, war equipment, and others. However, since many Talaandig are now becoming acculturated, the rule of property ownership followed is the one prescribed by legal authority. Ilo Convention Number 169. Procedure established by the peoples concerned for the transmission of land rights among members of these peoples shall be respected. The Indigenous Peoples' Rights Act, which states that the right to transfer land property shall include the rights to transfer land or property, rights to among members of the same ICCs or IPs, subject to customary laws and traditions of the community concerned. Comparative analysis between the three laws. Between the two laws, it appears that the tribal members are respected with their rights to pass or transfer their lands to their comrades and family. Under the same laws, the customary laws and traditions of these indigenous individuals are given much weight and deference as ways and means to transfer and pass lands and lands rights. However, under Ipra, the right of ownership between ancestral lands and ancestral domain is different. Ancestral domains cannot be passed on or transferred because the right to own them excludes the right to sell, dispose, or destroy, while ancestral lands can be transferred under Section 8. Ancestral domains are not alienable as they belong to all generations of ICCs IPs concerned. The same law even provided an extent of remedy in the event of transfers tainted with vitiated consent or unconscionable price. In case of land dispute, both parties will be brought to sala or trial. It is understood as the efforts or manner of this tribe in establishing and recognizing land rights. Sala is the term relayed by the leaders for the purpose of reconciliation. A ritual is performed where the history of such customary law is being elucidated to enlighten every party. Both sides will be heard within ample time. regardless whether the trial will take more hours to settle. Their issues and prayers shall be discussed by letting them explain their contentions and allegations. The concept of justice is based, according to the Datu informants, on the universal relationship of a man and nature, and particularly his relation with Magpapaya. It is likewise based on their history, which relates that conflicts in the past were properly investigated by delving into the cases. In Ilo Convention Number 169, it clearly states that adequate procedures shall be established within the national legal system to resolve the land claims by the peoples concerned. In UNDRIP, states shall provide effective mechanisms for just and fair redress for any such activities, and appropriate measures shall be taken to mitigate adverse environmental, economic, social, cultural, or spiritual impact. Indigenous Peoples' Rights Act states that in cases of conflicting interest where there are adverse claims within the ancestral domains as delineated in the survey plan and which cannot be resolved, the NCIP shall hear and decide after notice to the proper parties. The dispute arising from the delineation of such ancestral domains, provided that if the dispute is between and or among ICCs or IPs regarding the traditional boundaries of their respective ancestral domains, customary process shall be followed. The NCIP promulgate the necessary rules and regulation to carry out its adjudicatory functions. Comparative analysis between the three laws. These laws recognize the customary laws of any indigenous tribe to assist in hearing and adjudicating both the sentiments of all parties. These three instruments impart much weight to these customary laws as an applicable and relevant law when intertribal dispute arises, as the comprehension and solution of the problem goes within internally and among them. However, the state has to intervene when such conflict involves the right of a private individual or the state of the tribe.